Hello to all, myself Vandana Yadav, and today we are going to discuss India's longest case, the proceeding for which went for 68 days, the judgment for which contains more than 103 pages, and the constitution of more than 70 countries was compared before coming to the judgment and before deciding what is correct and what is not in this case. More than 100 plus cases were set aside in this case. Yes, we are talking about the most important case, Keshwananda Bharti versus State of Kerala 1973. This case was a culmination of a very serious tussle going on between the judiciary and the government. So हमें जब इंडिपेंडेंस मिला 1947 में तो सारे स्टेट्स अपने सोशल और इकोनॉमिक कंडीशंस को इम्प्रूव करने में लग गए थे. हमारा कॉन्स्टिट्यूशन बना, हमें फंडामेंटल राइट्स मिले और हमें पता चला कि इक्वालिटी भी हमारा एक राइट है. People of the state came to know that most of the wealth was concentrated in only few hands. Most of the means of production, most of the resources were concentrated in only few hands. Kerala being one of the states, उसने अपने जमींदारी सिस्टम अपने टेनेंसी लॉस को ठीक करने के लिए केरला की गवर्नमेंट ने केरला लैंड रिफॉर्म्स पास किया 1963 में. These Land Reforms Act decided the distribution of land in the state and this kind of restricted the property rights. It was then that an Indian Hindu monk, Keshwananda Bharti, the head of the Ednir Mutt, challenged this. A writ petition was filed by Keshwananda Bharti challenging and opposing this Land Reforms Act of 1963, and the case was represented in Supreme Court by Nanaji Palkhiwala. केशवानंद भारती said that rights to own land is a fundamental right. उस टाइम पर कुछ और भी इंपॉर्टेंट केसेस चल रहे थे जैसे कि बैंक नेशनलाइजेशन केस और गोलकनाथ केस. And there was a tussle going on between the Parliament and the Supreme Court. The Parliament said that through Article 368, it had power to amend the Constitution to no limits, to which the Supreme Court did not agree, and imposed restrictions on amending the Constitution, after which the Parliament passed the 24th Amendment Act, the 25th Amendment Act, and the 29th Amendment Act. Let us now understand these three amendments. So, through the 24th Amendment Act, the Parliament has power to amend any provision in the Constitution. Through the 25th Amendment Act, the right to property can be curtailed and government can acquire any public land for private use. And through the 29th Amendment Act, Land Reforms Act was put in the ninth schedule. Now, what is so special about this ninth schedule? तो जो भी लॉज नाइन्थ शेड्यूल में डाले जाते हैं उन पर सवाल नहीं उठाया जा सकता है. They cannot be reviewed, and so the Land Reforms Act, by becoming a part of the ninth schedule, got immunity from any kind of interference by the court. इस केस में बहुत सारे मुद्दे उठाए गए थे जिसमें से दो बहुत इंपॉर्टेंट थे. The first was that can the parliament amend the constitution, and the second was, if yes, if parliament can amend the constitution, then to what extent is its amending power. तो एक तरफ थे पेटिशनर्स और एक तरफ थे रिस्पोंडेंट्स. पेटिशनर्स को लीड कर रहे थे केशवानंद भारती जिनका कहना था द पावर ऑफ द पार्लियामेंट under Article 368 is limited and cannot be misused. They said that fundamental rights have been given to protect the freedom of the citizens. Respondents, on the other hand, had something else to say. They said that Parliament has got unlimited and absolute power to amend the Constitution, and if this power is curtailed, then states won't be able to change their social and economic conditions with the changing times. There was a case before this, which is called the Golaknath versus State of Punjab, in which the Supreme Court held that the Parliament could not amend the fundamental rights and the power to amend the Constitution would only be with the Constituent Assembly. Coming to the judgment of Keshwananda Bharti, a 13 judges bench, longest so far, was constituted. It was set up by the Supreme Court, the biggest so far, to hear this case. And by a thin majority of 7:6, the judgment of Golaknath versus State of Punjab was overruled in Keshwananda Bharti versus State of Kerala. Also, the 24th Amendment Act was held to be valid. आर्टिकल 368 के अंडर पार्लियामेंट के पास पूरी पावर है कि वो कॉन्स्टिट्यूशन के किसी भी प्रोविजन को अमेंड कर सकती है. Now the second question. The first question having been answered, let us come to the second question, that to what extent can the constitution be amended by the parliament? To this, the Supreme Court said the amending powers should be used so as not to disturb the basic structure of the Constitution. so as not to alter the basic structure of the Constitution. Also, the 25th and the 29th Amendment Act were held to be valid. The Supreme Court also said that any law put in the ninth schedule, if violative of the basic structure of the Constitution, will be under judicial review, unlike before, and they can be challenged in the court. So, on 24th April 1973, 50 years back, the landmark decision of the Supreme Court gave birth to the basic structure doctrine, and there was no exhaustive list given of the basic features, but though there was an indicative list. And also, in the coming times, more things can be added in that list. Why is this case so important? This case gave birth to a new doctrine which is called the basic structure doctrine, and इस केस ने आने वाले सालों के लिए इंडिया की डेमोक्रेसी को भी सेव किया. Thank you so much.